Hello friends, in the previous sessions, third C when it comes to the validity of a contract or essentials of a valid contract, the first two being capacity to contract as well as consideration to contract. First in line is the concept of coercion, wherein we would see how the Indian Contract Act defines the term coercion as well as how coercion under Indian law is different from the concept of duress under English law. To start with, coercion as defined under the Indian Contract Act is the committing or threatening to commit any act forbidden by the Indian Penal Code. Yes, although the Contract Act still mentions the term Indian Penal Code, but we all know that in 2023 we have got Bharatiya Nyaya Sanhita, or the unlawful detaining or threatening to detain any property to the prejudice of any person whatever with the intention of causing any person to enter into an agreement. So, it basically says a person who wishes to obtain the consent, a party who wishes to obtain consent of another party, another person, and wants that person to enter into a contract with him, then in that case coercion means that if that person, in order to obtain such consent, commits or even threatens to commit any offence which is punishable act, punishable offence under the Indian Penal Code, or secondly unlawfully detains, that is keeps in his possession, unlawfully detains or threatens to detain any property to the prejudice of any person whatever with the intention of causing any person to enter into an agreement. Now you will see, you are seeing here that it says any person, any person. So what is the significance of this any person? If we are talking about contract, we should talk about two parties, one party or the other party. What do we mean by any person here? We would be getting to this point in one of our later slides. The next thing which is mentioned in the provision section 15 of the Indian Contract Act is the explanation appended to the section. It says it is immaterial whether the Indian Penal Code is or is not in force in the place where the coercion is employed. Coercion is said to be exercised when consent is obtained by pressure, which is exerted by, as we just read in the definition stated under Indian Contract Act, by committing or threatening to commit any act forbidden by Indian Penal Code, or unlawfully detaining or threatening to detain any property. For your better understanding, you can see on your screen certain examples have been highlighted. So, if we go through them, consent obtained by threatening to kill, by shooting pistol, by threatening to cause hurt to a person, by threatening to set a person's house on fire. All these examples are of coercion. Now there is this very highlighted judgment. You will see this judgment as is mentioned here on the screen, Chikham Amiraju versus Chikham Seshamma. You will come across this judgment many a times, whichever textbook on law of contracts you will read. It is a very important judgment of Madras High Court which came in 1918. So, in this judgment, a person threatened to commit suicide if his wife and son refused to execute a release in favor of his brother with respect to certain properties which the wife and son claimed to be their own. Now, we just saw in the definition, it says any act forbidden by the Indian Penal Code. If a person commits or threatens to commit any act forbidden by Indian Penal Code. Here in this judgment, person was threatening to commit suicide. Now the question arose, does this threat to commit suicide in order to obtain consent of his wife and his son, did it amount to coercion? It was held that the threat of suicide did amount to coercion under section 15 and it was held that in this case the coercion which was exercised by the husband on his wife and father on his son to get this release executed was voidable. Now the next part, second part of definition of coercion highlights detention of property. So one part was committing or threatening to commit any offence which is punishable or forbidden by law of the under the Indian Penal Code. The second part highlights detention of property or threatening to detain any property. Now what do we mean by detain? I just told you detain means you, and basically unlawfully detaining means that you do not have the right of possession over that property, but you continue with the possession of that property against the interest of the person who should actually be in the possession of it. Now let us see, an example has been highlighted here. So X pledged a piece of jewelry with Y for 30,000 rupees. So he pledged his piece of jewelry, gave it to Y, and in return he got 30,000 rupees. Now when X goes to redeem it, that is, he goes to give back to return the repay the amount which had been which he had received, which he had borrowed. In that situation, the pledgee, that is Y, insists that an additional amount of 5,000 was also owed by X to Y. That means 20,000, this 30,000 so you have to give, because you had pledged your piece of jewelry with me. Now you are and I had given you 30,000. So now you are, if you want to get this piece of jewelry back, apart from what you owe me in form of the amount which you had borrowed, you also have to give this 5,000 additional to me. At that point, at that juncture, in order to get that piece of jewelry back, this person X, he paid that additional amount, but he later on sued Y in order to recover that amount. Now question arises, will he succeed? Because he has already given that money and he had got his piece of jewelry back which had been pledged. Now can he successfully recover that amount? The answer is, it can be recovered. Now let us compare it with English law. Let us compare the concept of coercion under the Indian law, under the Indian Contract Act, with the concept of duress under English law. There are certain stark differences between the two concepts of coercion and duress. You can see on your screens, it is mentioned that the concept is coercion, concept of coercion is identified as duress under English law. Now let us see how can we distinguish between both these concepts, what is the difference between them. Now it says coercion includes unlawful detention of property also. Remember, threatening to commit an offence under IPC, or unlawfully detaining or threatening to detain any property. So this second part of section 15 which emphasizes upon unlawful detention of property, regarding that it has been, the first point of difference is regarding that under English law unlawful detention of property is not covered under duress. Now coercion can also be committed by a person who is not a party to the contract. Remember, let us go back to the previous screen. We highlighted this, any person here. So who can commit coercion? Against whom coercion can be committed? So that is why this any person comes into picture. That means coercion can be committed by any person and it can be committed against any person, need not necessarily be party to the contract. That is why any person. Let us go back to the difference. So coercion can also be committed by a person who is not party to contract and can be directed to a stranger also. Any person who is not a party to contract can commit coercion, and any person who is not a party to contract, against that person coercion can be committed. But is it the same in English law also? The answer is no, because duress refers to actual or threatened violence against party to contract or his near family, that is wife, parent, child, but not stranger unlike the Indian law.